The people didn't even bring up the THC. That's the least of my concerns, frankly. It is the cocaine, it is the fentanyl, it is the mistest, it is the disrespect, it is the way he treated community corrections. I'm very concerned, and I continue to ask.
Honestly, Your Honor, I'm not using. I'm not. I can go across the street. You could take me in the back, drop me. I'm not. I work every day and go to my kids' practice.
That he uses marijuana and it's being utilized under his doctor's care. I don't know whether he got that letter this morning, as he and I spoke about 5:30 p.m. last night, but he will plead guilty to the violation because he is responsible for the any content that he puts into his body, but it was not intentional. It was only intended to use marijuana, and we will provide, Your Honor. I don't think he needs to be locked up, Your Honor. This is something he can adhere to, Your Honor's conditions, and make sure that any future use is with Your Honor's approval and proof to the court.
And Your Honor, if I may have a moment, when I spoke with my client yesterday, he indicated there was an issue with his medical card. He has indicated he's obtained a new medical license, and he actually pulled up the that new license.
What I say, I'm not worried about the THC.
I was going to request the court to send him over to community corrections to get him tested today to see if it's just the THC in his system now that he has his license and getting it through a legitimate source. Understanding if anything other than THC comes back, I understand where the court's going to want him to be staying.
The people didn't even bring up the THC. That's the least of my concerns, frankly. It is the cocaine, it is the fentanyl, it is the mistest, it is the disrespect, it is the way he treated community corrections. I'm very concerned, and I continue to ask for a remand.
Judge, I do not believe that this was intentional, disrespectful, or any intention to use anything other than his THC. I think that if he stops purchasing his marijuana on the street and subjected to the dirty weed that he got, and now that he has his card, we're not going to have these issues. Judge, I would ask that you put him in jail if he violates again. After speaking with him, I do not think we're going to be here on any future violations. He doesn't use those drugs. He doesn't want to use those drugs. And anything in his body was purely not intentional. We shouldn't have this issue again.
Again, Your Honor, I would just request that the court is inclined to follow the people's recommendation. We afford my client a chance to go get tested at community corrections now to see if it is just THC at the point because he has his license, or if he's going to show dirty for those other substances.
His actions at community corrections, Mr. Johnson knows what I expect of him.
Yes, I do.
And very clear at that. We have gone round and round at times. And he understands that I have the expectation, certainly, that he not act in a certain way. What he did over community corrections is, but I will say this. When Mr. Johnson, my impression, when Mr. Johnson starts doing that, stuff like that, it's because he's using. When he's not using, he's a completely different individual.
And Your Honor, I stand at the disadvantage here as I've just met my client now.
May I say one thing? Possibly.
Go ahead.
Yeah, I know your expectations, Judge Simpson. I've been dealing with you for years. I haven't been in this courtroom in a while. I've been staying out the way. I haven't been in using. And back in the day, you know, the image you have, arguing, confrontation. Of course, you know me. That's not that. I'm not doing, like I said, I was using the marijuana, purchase it. I'm not making no excuses for none of my behaviors, nor the dirty drops or none of that. Because that, like he said, my attorney said, I plead guilty to the violations because I am what I consume. But that day, I was going through with a relationship issue. So I was kind of irritated anyway. You know what I'm saying? But I ain't over there with community corrections dropping. I just dropped on the 30th.
Mr. Johnson, you can't tell me that by what you did.
Yes. And I understand.
I mean, you just can't tell me that. Saying I don't have any issues. These folks don't need to be treated that way. They're just doing their job.
And I totally understand that. I apologize.
My other problem is maybe I buy what counsel's saying. If your test showed up,
Did you? I'm
you
sorry.
had just one. But you know, it's dirty on July 31st. It's dirty on the 12th.
And I dropped on the 13th, I believe, as well. After that, so I'm willing to go over there right now. I know I'm clean. I know I don't do drugs. I know I ain't.
I'm not doing that today. I'm not gonna sit up here and mess around with you. You know how you're supposed to act. You know what you're not supposed to do. Know that.
Yes, sir.
You also know yourself well enough to know that when you're using like this, that's when you start doing that stupid stuff.
Honestly, Your Honor, I'm not using. I'm not. I can go across the street. You could take me in the back, drop me. I'm not. I work every day and go to my kids' practice.
I will adjourn the probable cause conference in these matters to the 27th of August, 2026. So we're just going to adjourn it out a week. But at this time, we're just going to have to get it straight again, Mr. Johnson. I'm not playing. Bonds revoked, defendants remanded.
Mr. Johnson stood before the judge hoping for another chance. But the court had serious concerns. Failed tests, disrespectful behavior, and repeated warnings painted a troubling picture. As the hearing unfolded, the judge made it clear that accountability mattered. In the end, Johnson's bond was revoked, and he was remanded.
Good morning. Go ahead, put your appearance on, counsel. She's here.
If it please the court, Attorney Sharon Jones, P number 57113, on behalf of Tia Daniel.
Your name, ma'am?
Tia Daniel.
Thank you. All right. And what are we doing today on this case?
Your Honor, we'd like to set this for a preliminary exam.
All right. Is all discovery complete?
That appears to be so. I've received the digital discovery recently, and I have the paper discovery, so I think I have everything.
All right. Bless you. Would people have their witnesses available to first? I would set. Doing. Shit. Hold on one moment. Mr. Allen. Counsel, have you seen the community corrections report?
Your Honor, I did receive a bond violation report regarding the electronic monitoring. I did discuss that with Daniel, yes.
Okay, well, let's deal with that first because this is concerning to the court, certainly.
Would you like me to begin, Your Honor?
Yes, go ahead.
Well, Ms. Daniels indicates that she was not violating the court's order not to consume alcohol, but we believe she perhaps did utilize something that may have resulted in a false positive on August 16th that evening. And Your Honor, she understands what the court expects of her. She doesn't have any prior history, to my understanding.
Hold on, counsel. And I hear what you're saying, and I understand you know with what your client is saying, but she's saying that vanilla extract, I'm presuming, caused her to blow a .073?
Well, Your Honor, I'm no expert on what might result in false positives. But I know that was a single incident, Your Honor, and she understands not to do things that might throw her compliance into question. We're just asking for the court.
Is she really going to maintain that story to me?
I don't know, Your Honor, personally, but
hold on a minute.
Can't explain. I'm sorry.
Vanilla? It'll be a party. Go ahead.
I believe vanilla does have alcohol in it, if I'm not mistaken.
Well, then there's a problem. Because it had alcohol in it, she can't take it anyway. Doesn't matter. It doesn't have to be a beer or a shot of bourbon or scotch. She can't have alcohol.
She understands. I'm sorry.
No, those are the rules. And then if she's going to claim that it's vanilla extract that caused this, she just says vanilla, but she blows a 0.073 at 9:22. 20 minutes later, it's an 0.63. 15 minutes after that, she's at an 0.53. And then she decides she's not going to retest, which is also a violation.
I don't think she decided not to retest. I think she thought that those tests that she did, the retest that she did, may have been all. I know that she did go to bed. So she, Your Honor, it was a mistake on her part, and we're just asking for another chance.
I don't mind giving people chances if they're truthful with me. But if you're going to sit up here and say that this was vanilla, I'm not buying it. We'll hold a hearing. I won't set it for exam. We can hold a hearing next week on this.
If that's the court's
The client wants to say something.
Okay.
Go ahead, man.
I did have a drink, Your Honor.
Then why did you have your counsel, first of all, why'd you then lie to community corrections and then have your counsel up here trying to advocate for you and you lied to her?
I was scared, Your Honor.
You were scared? Should be. The one thing you shouldn't do is lie to any court, and particularly not this one. Here's what I'm going to do. I'm not going to set it for exam. I'm going to adjourn this probable cause conference out 1 week to the 27th, 2026, 9 a.m. At this point, though, defendant's bond is revoked. Defendant's remanded. Court calls the case. People versus Elise Daniel.
Assistant Public Defender, earlier, on behalf of Ms. Daniel.
Daniel didn't want to come up here after that.
Here,
What? Don't be scared. What's your name, ma'am?
Elise Renee Daniel.
Thank you. All right, what are we doing?
I have made contact with Ms. Daniels. We do have a telephone number for her, and you instructed her to answer her phone. May I approach her, Honor?
Thank you.
So now you have all the information to contact.
That is correct.
All right. Contact with your attorneys. Okay. I will adjourn this out to September 17th, 2026, 9 a.m.
Okay. Here. Okay. Thank you. Thank you, Your Honor. You know your name. The one that's called in this one.
The one, oh,
The one you just called, is this one?
oh, that's a codependent with her. Oh, okay. Well, cases will catch up eventually. Thank you.
I didn't know what you were gonna do next week.
Right. Oh. Court calls the case, People versus Ronald McQueen.
People, Your Honor.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. McQueen, who is appearing via Zoom.
Mr. McQueen, can you unmute, state your name, please?
This is Ronald McQueen.
Thank you.
At this time, Your Honor, we requesting to set this matter for preliminary, and to my knowledge, all discovery is complete.
You will have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination will be set September 1st, 2026, 9 a.m. That is before
Judge Perry.
Judge Perry. Thank you.
Thank you, Your Honor.
Bond continued. Court calls the case, People versus Nicholas Meath.
Good afternoon, Your Honor. Raymond Cook with People.
Sorry, Your Honor. Assistant Public Defender Natalie Pate on behalf of Mr. Meath, who has already stated his name. Your Honor, I am requesting an adjournment I did email Mr. Cook this week and he responded. He actually responds very quick. So in the spirit of defensiveness, I did.
Not what that other guy said.
I know. So in the spirit of defensiveness, I want to tell the truth. I did in fact email him and he did in fact respond back very quick. Not only did he let me know that the media would be on its way very shortly, since he sent that email, we did get it. So we just got it. I am asking
That. Hold on a moment. Who? Oh, it was Andy? Oh, it's okay. No, you're good. If it's yours, go ahead. I just didn't know if it was going to be canon. That's what I was looking for.
Apologies, sure.
No, no. Yeah. Go ahead.
Oh, sorry, Your Honor. So the good news is we now actually have it. We just got it. So I do need some time to review it and then discuss it with my client.
Fine.
So a 2-week adjournment would be excellent if possible. 3 would be fine too. Or even 1. I could review it very quick.
You know what? Peyton knew, and I said earlier, I have 1 in 3 weeks. He always pays very close attention. Trying to trip me up by saying I'll take 2.
I usually pay close attention, but honestly, I think I could.
September 10, 2026, 9 a.m.
Thank you, Your Honor.
On continued. Thank you, sir.
Thank you.
Thank you, Your Honor. Court calls case, People versus Brian Miner.
Assistant Public Defender, really on behalf of Brian Minor. Your name for the record, dear?
Brian Dugald Minor. Thank you.
Judge, we're asking for an adjournment. I think we are on the tail end of our mitigation efforts.
What does that mean?
They finished the fact finding and gathering portion and they're working on the drafting portion.
Tail end. So, finish this journey. How much more time you need?
I think 2 weeks actually should be fine.
You want to know what? What did I just say to Pate? What did I just say?
Okay.
Wait, we have to stop this car.
No.
All right. We'll adjourn this to September 17th, 2026.
Thank you, Judge.
Thank you, Your Honor.
You're welcome, sir.
Okay, you need both? You need something.
Court calls the case of the People of the State of Michigan versus Matthew Morrison, aka Esther Murphy.
That's the call for the people.
Hey, Lucas, on behalf of Miss Murphy, if you could please state your name.
Oh, you're muted.
Hello, this is
Got
Esther.
Say again.
This is Esther Murphy.
Thank you. All right, what do we do?
We're seeking to adjourn. We haven't had a chance to meet with our client yet.
You haven't had a chance to speak to her?
No.
All right. I will adjourn the probable cause conference in this case to September 17th, 2026, 9 a.m. Bond continued.
Thank you.
Why? Court calls the case, People versus Cody Murray.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Murray, who should be appearing via Zoom.
There he is. Sir, please state your name.
Cody Murray. Thank you for your time, Your Honor.
At this time, Your Honor, I would be requesting adjournment to finalize negotiations with the people. I am fine with a 3-week adjournment, Your Honor.
Not just one?
Thank you. Finally, somebody's attention. I'll adjourn.
I'm in here more often than you.
I'll adjourn the matter to September 10th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Mr. Murphy. Court calls the case, People versus Matthew Myers. Bukovich is going to throw all of you under the bus.
And on behalf of the Your Honor.
Assistant Public Defender, Shania Carey Ruley, on behalf of Mr. Matthew Myers, on Zoom.
Oh, there he is, I think.
Mr. Myers, would you say it for the record?
Yes, Matthew Meyer.
All right.
Judge, Mr. Feaster is still working on negotiations in this.
Why didn't
You know, Judge. He says that he is fine with a 3-week adjournment, Judge.
Feaster did not say that. Well, if he wants 3 weeks, I'm not giving him that.
Okay. He's got to deal with it, you know?
Wow. Abandoned him just like that.
That's right.
I will adjourn your case to September 17, 2020, 9 a.m.
Thank you, Your Honor.
Thank you, sir. Bond continued. Court calls the case of the people versus, is it Ahat Nelson Chambers?
Asia Nelson.
Asia? Really? It's like the 15th different way it's been spelled. Is that really Asian?
Are they?
It's an Aja.
Aja.
So hold on a second. All right, so what's your name?
My name's Aja Nelson Chambers.
Aja. That actually makes more sense than Asia.
Yeah, no, it's all me. Anyway.
It's just Aja. I knew that.
She knows I have a problem with me. It's okay. All the time. Your Honor, we are, to our knowledge, discovery is complete. We're requesting to have a preliminary exam scheduled.
All right. Would people have their witnesses available the first? Preliminary examination will be set for at 1st, 2026 at 12 noon before me. So I can mispronounce your name one more time. All right. Thank you. Bond continued. Court calls the case. People versus Patricia Pacheco.
On behalf of